Question 1. Which approach would be most appropriate for a real estate licensee in British Columbia when a seller wishes to retain a specific, non-contiguous portion of their property for personal use after the sale, while selling the remainder to a buyer? Option A. Proceed with the sale of the entire property as described in the listing, and then advise the seller to informally demarcate the retained area on the ground after closing, trusting that the buyer will acknowledge this informal arrangement. Option B. Rely on the seller's detailed description of the retained area and include a clause in the contract of purchase and sale stating the seller's intention to retain that specific portion, assuming it will be respected by future owners. Option C. Conduct a comprehensive title search to identify any existing easements or covenants, consult with the seller to understand their precise intentions, and advise seeking legal counsel to formally establish the retained interest and any necessary rights of way or restrictions through appropriate legal documentation and registration on title. Option D. Advise the seller that retaining a portion of the property after selling the rest is not legally feasible and suggest they sell the entire parcel as is, or not at all. Correct answer is C. Conduct a comprehensive title search to identify any existing easements or covenants, consult with the seller to understand their precise intentions, and advise seeking legal counsel to formally establish the retained interest and any necessary rights of way or restrictions through appropriate legal documentation and registration on title. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a potential conflict between a seller's desire to retain a portion of their property and the legal framework governing property rights in British Columbia. A real estate professional must navigate the complexities of land ownership, easements, and covenants to ensure a legally sound and ethically compliant transaction. Misinterpreting or misapplying property law can lead to significant legal disputes, financial losses for clients, and damage to the professional's reputation and licensing. Correct approach analysis. The best approach involves a thorough examination of the British Columbia Land Title Act and relevant case law concerning easements and restrictive covenants. This requires understanding how such rights are created, registered, and their implications for future use and ownership. Specifically, verifying the existence, nature, and enforceability of any proposed retained interest by the seller through a title search and legal consultation is paramount. This ensures that the proposed sale accurately reflects the legal realities of the property and protects both the buyer and seller from future disputes. This approach aligns with the duty of care owed to clients under the Real Estate Services Act of British Columbia, which mandates competence and diligence in all professional dealings. Incorrect approaches analysis. One incorrect approach would be to rely solely on the seller's verbal assurances or informal agreements regarding the retained portion of the property. This fails to acknowledge the legal requirement for formal registration of property interests under the Land Title Act. Verbal agreements regarding land are generally unenforceable and do not bind future owners. This approach demonstrates a lack of due diligence and exposes the buyer to significant risk. Another incorrect approach would be to proceed with the sale based on a superficial understanding of the seller's intent without verifying the legal mechanism for creating such a retained interest. For instance, assuming a simple subdivision without confirming the legal feasibility or the creation of necessary easements or covenants would be a critical error. This overlooks the detailed legal requirements for severing and retaining specific rights over land. A further incorrect approach would be to advise the seller to simply exclude the area from the sale agreement without establishing the legal framework for the buyer to access or use the remaining property, or for the seller to retain rights over it. This could lead to a situation where the buyer owns land that is inaccessible or where the seller's retained rights are unclear, creating ongoing disputes and potential litigation. Professional reasoning. Professionals should always prioritize verifying legal rights and obligations through official documentation, and when necessary, expert advice. In property transactions, this means conducting thorough title searches, understanding the implications of registered charges and interests, and ensuring all agreements are legally sound and enforceable. When dealing with complex property rights, consulting with legal counsel is a critical step in fulfilling professional obligations and protecting client interests. Question 2. Risk assessment procedures indicate a need to clarify common property ownership structures for clients purchasing real estate in British Columbia, A licensee is explaining the difference between fee simple and leasehold ownership. Which of the following explanations most accurately reflects the legal distinctions under British Columbia law? Option A. A leasehold interest is merely a temporary permission to occupy a property, lacking any legal right to possession that could be enforced against the owner. Option B. Fee simple ownership represents the most extensive form of ownership, granting indefinite rights to possess, use, and dispose of the land, whereas a leasehold estate grants the right to exclusive possession and use for a specified period, with ownership of the land remaining with the landlord. Option C. Both fee simple and leasehold ownership grant identical rights to occupy and use the property indefinitely, with the primary difference being the initial purchase price. Option D. Fee simple ownership is always a superior form of ownership to any leasehold ownership, regardless of the terms of the lease. The correct answer is B. Fee simple ownership represents the most extensive form of ownership, granting indefinite rights to possess, use, and dispose of the land, whereas a leasehold estate grants the right to exclusive possession and use for a specified period, with ownership of the land remaining with the landlord. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a real estate licensee in British Columbia to accurately advise clients on the implications of different ownership structures, specifically distinguishing between fee simple and leasehold estates. Misunderstanding or misrepresenting these distinctions can lead to significant legal and financial consequences for the parties involved, potentially resulting in disputes, loss of property rights, and damage to the licensee's reputation and professional standing. Licensee must demonstrate a thorough understanding of the Land Title Act, British Columbia, and common law principles governing property ownership. Correct approach analysis. The best professional practice involves clearly differentiating between fee simple and leasehold ownership by explaining that fee simple represents the highest form of ownership, granting the owner the most extensive rights to the land, including the right to possess, use, and dispose of it indefinitely, subject only to governmental powers and encumbrances. In contrast, a leasehold estate grants the right to exclusive possession and use of land for a defined period, but ownership of the land itself remains with the landlord. This approach is correct because it directly addresses the core legal distinctions mandated by British Columbia property law, ensuring clients understand the fundamental nature of their property rights and obligations. Incorrect approaches analysis. Advising that both fee simple and leasehold ownership grant identical rights to occupy and use the property indefinitely is incorrect. This fails to recognize the crucial difference in the duration and nature of the rights conferred by each estate, violating the principle of accurate representation required under the Real Estate Services Act, British Columbia, and its associated rules, suggesting that a leasehold interest is merely a temporary permission to occupy without any legal right to possession, is also incorrect. Leasehold estate, while for a defined term, grants the tenant exclusive possession, which is a legally recognized right, not just a revocable permission. Misrepresenting this can lead to breaches of contract and professional misconduct, stating that fee simple ownership is always superior to leasehold ownership without considering the specific terms and benefits of a particular leasehold agreement is an oversimplification. While fee simple offers greater control, certain long-term leasehold arrangements can provide significant benefits and security of tenure, and the licensee's role is to explain the nuances, not to make subjective pronouncements of superiority without context. Professional reasoning. Professionals should approach such situations by first identifying the specific type of property interest being discussed. They must then consult relevant legislation, such as the Land Title Act, British Columbia, and established legal principles to accurately define the rights and obligations associated with each interest. Clear, concise, and accurate communication with clients is paramount, ensuring they fully comprehend the implications of their chosen ownership structure. When in doubt, seeking clarification from legal counsel or experienced colleagues is a responsible professional practice. Question 3. Strategic planning requires a real estate professional in British Columbia to possess a nuanced understanding of the subject matter. Which of the following best encapsulates the definition and importance of real estate in the context of professional practice? Option A. Real estate is simply a commodity to be bought and sold for the quickest possible profit, with little regard for long-term implications. Option B. Real estate is primarily defined by its physical characteristics, such as size, construction materials, and immediate neighborhood amenities. Option C. Real estate's importance is solely determined by its current market price and its potential for short-term capital gains. Option D. Real estate is a multifaceted asset encompassing legal rights, economic value, and social impact, serving as a significant component of personal wealth, investment, and community development. The correct answer is D. Real estate is a multifaceted asset encompassing legal rights, economic value, and social impact, serving as a significant component of personal wealth, investment, and community development. Explanation: this scenario presents a professional challenge because it requires a real estate professional in British Columbia to understand the fundamental definition and importance of real estate beyond mere physical property. The challenge lies in discerning which approach best reflects the comprehensive understanding required by the Real Estate Services Act (RESA) and its associated regulations, which govern the conduct of licensees. A deep understanding of real estate as an asset class, its economic implications, and its legal framework is crucial for providing competent advice and fulfilling fiduciary duties. The correct approach emphasizes understanding real estate as a multifaceted asset with legal, economic, and social dimensions, recognizing its significance in investment, development, and personal wealth. This aligns with the professional obligations under RESA to act with honesty and integrity, and to possess the knowledge and skill to provide competent service. A licensee must be able to articulate the value and implications of real estate to clients, which extends beyond simply identifying a physical structure. This comprehensive view is essential for advising clients on purchase, sale, or investment decisions, ensuring they understand the full scope of what they are engaging with. An incorrect approach that focuses solely on the physical attributes of a property, such as its size, condition, or location, fails to acknowledge the broader definition and importance of real estate. This narrow perspective overlooks the legal rights and interests associated with property ownership, the economic factors influencing its value, and its role in the broader economy. Such a limited understanding could lead to inadequate client advice, potentially resulting in poor investment decisions or missed opportunities, and could be seen as a failure to meet the standard of care expected of a licensed professional under RESA. Another incorrect approach that views real estate merely as a commodity to be traded for profit, without considering the client's specific needs, financial situation, or long-term goals, is ethically problematic. While profit is a component of real estate transactions, a professional's primary duty is to their client. This approach neglects the fiduciary responsibilities and the importance of client-centric advice, potentially leading to transactions that are not in the client's best interest. This contravenes the ethical principles of acting in the best interests of the client, as mandated by RESA. A further incorrect approach that considers real estate only in terms of its immediate market value, without considering its potential for future appreciation, development, or its impact on the community, is also insufficient. Real estate's importance extends beyond its current market price. It involves future potential, land use, and its contribution to the social and economic fabric. A professional must be able to guide clients on these broader implications, demonstrating a holistic understanding of the asset. The professional reasoning process should involve first identifying the core concept being tested, the definition and importance of real estate. Then, evaluate each option against the foundational principles of real estate as an asset, its legal and economic significance, and the professional obligations of a British Columbia real estate licensee under RESA. The best approach will be the one that demonstrates the most comprehensive and ethically sound understanding, enabling competent and client-focused service. Question 4. Market research demonstrates that a property listed in Surrey, British Columbia, for $850,000 has received an appraisal valuing it at $810,000. The buyer's lender is now reviewing the loan application based on this appraised value. As the listing real estate licensee, what is the most appropriate course of action to ethically and professionally manage this situation? Option A. Contact the appraiser and strongly encourage them to reconsider their valuation, emphasizing the listing price and recent comparable sales that support a higher value. Option B. Provide the lender with selective comparable sales data that supports the $850,000 listing price, omitting any comparables that might justify the lower appraised value. Option C. Inform the lender of the appraised value and discuss any relevant market factors that might explain the difference between the listing price and the appraisal, while also advising the client of the appraised value and the lender's likely position. Option D. Advise the buyer to withdraw their offer immediately, as the appraisal is significantly lower than the listing price, and suggest relisting the property at a lower price without further discussion. The correct answer is C. Inform the lender of the appraised value and discuss any relevant market factors that might explain the difference between the listing price and the appraisal, while also advising the client of the appraised value and the lender's likely position. Explanation. This scenario presents a professional challenge because it requires a real estate licensee in British Columbia to balance their fiduciary duty to their client with the lender's underwriting requirements and the ethical obligation to provide accurate information. The licensee must avoid misrepresentation or misleading the lender, which could have serious legal and professional consequences. Careful judgment is required to navigate the potential conflict between assisting the client in obtaining financing and upholding professional integrity. The best approach involves transparent communication with the lender and the client. The licensee should clearly explain to the client that the property's actual market value, as determined by the appraisal, is what the lender will use for underwriting. The licensee should then inform the lender of the appraised value and any relevant market conditions that might explain discrepancies between the listing price and the appraisal, without attempting to unduly influence the lender's decision. This upholds the licensee's duty of honesty and integrity, as mandated by the Real Estate Services Act (RESA) and the Code of Ethics, which require licensees to be truthful and not mislead any party in a transaction. An incorrect approach involves pressuring the appraiser to increase the valuation. This is unethical and potentially illegal, as it constitutes an attempt to influence the appraisal process, which is designed to be an independent assessment of value. Such an action violates the licensee's duty to act with honesty and integrity, and could lead to disciplinary action under RESA. Another incorrect approach is to misrepresent the property's condition or recent comparable sales to the lender to justify the higher listing price. This is a direct violation of the duty of honesty and integrity and constitutes misrepresentation, which is prohibited by RESA and the Code of Ethics. It could also lead to the client being approved for a loan they cannot afford, creating further ethical and legal complications. Finally, an incorrect approach is to advise the client to withdraw the offer and relist at a lower price without fully exploring all avenues of communication with the lender and appraiser. While a price adjustment might eventually be necessary, immediately suggesting this without attempting to clarify the situation with the lender and appraiser bypasses a crucial step in the professional process and may not be in the client's best interest if the lender is willing to proceed with the appraised value. Professionals should employ a decision-making framework that prioritizes honesty, transparency, and adherence to regulatory requirements. This involves understanding the client's goals, the lender's requirements, and the licensee's ethical obligations. When faced with a discrepancy, the first step should always be to seek clarification and communicate openly with all parties involved, ensuring that all information provided is accurate and not misleading. Question 5. Risk assessment procedures indicate that a real estate licensee in British Columbia is tasked with valuing a property that includes a specialized, purpose-built agricultural processing facility alongside standard farm land. Given the unique nature of the processing facility, which valuation method would best serve the client's need for an accurate and market-relevant opinion of value, and why? Option A. The cost approach, estimating the current cost to construct a similar agricultural processing facility and adding the market value of the surrounding farm land. Option B. A hybrid approach that heavily emphasizes the theoretical replacement cost of the specialized facility, with minimal consideration for recent sales of similar agricultural operations. Option C. A comparative market analysis, focusing on identifying and adjusting for the most similar agricultural properties with comparable processing infrastructure that have recently sold or are currently listed in the local market. Option D. The income approach, primarily calculating the potential net operating income the agricultural processing facility could generate and capitalizing that income stream. The correct answer is C. A comparative market analysis, focusing on identifying and adjusting for the most similar agricultural properties with comparable processing infrastructure that have recently sold or are currently listed in the local market. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate licensee in British Columbia because it requires them to select the most appropriate valuation method for a unique property type, balancing the needs of a client with the ethical and regulatory obligations under the Real Estate Services Act, RESA, and its associated rules. The challenge lies in understanding the limitations of each valuation method when applied to a property that doesn't fit standard residential or commercial molds, and ensuring the advice provided is accurate, objective, and in the client's best interest. Misapplication of a valuation method could lead to an inaccurate market opinion, potentially causing financial harm to the client and violating the licensee's duty of care. Correct approach analysis. The most appropriate approach in this scenario is the comparative market analysis, CMA. A CMA is fundamentally about identifying comparable properties that have recently sold or are currently listed in the same or a very similar market area. For property with unique features, such as a specialized agricultural facility, the licensee's expertise is crucial in identifying truly comparable properties. This involves adjusting for differences in size, condition, zoning, and critically for this property, the specific agricultural infrastructure and its marketability. The Real Estate Services Act, RESA, and the rules require licensees to provide competent service, which includes having the knowledge and skill to perform the services undertaken. While the income approach and cost approach can be supplementary, the CMA forms the bedrock of a market-based valuation for most real estate, especially when direct comparables, even with adjustments, can be found. The ethical obligation to act in the client's best interest necessitates using the method that most directly reflects current market conditions and buyer behavior for similar properties. Incorrect approaches analysis. Relying solely on the income approach would be problematic. While income-generating potential is a factor, the specialized nature of the agricultural facility might mean that comparable income data is scarce or unreliable. The income approach is best suited for properties where income is the primary driver of value and where a robust market for that income stream exists. Without sufficient comparable income data, this approach could lead to an inflated or deflated valuation. The cost approach, which estimates the cost to replace or reproduce the property, is also less suitable as a primary method here. It often overestimates value for older properties or those with specialized, non-standard construction, and it doesn't directly reflect what a buyer is willing to pay in the current market. The marketability of specialized agricultural improvements can be highly variable, and their replacement cost may not align with their actual market value. Both of these approaches, if used exclusively without strong supporting data, could violate the duty of care owed to the client by providing a potentially misleading valuation. Professional reasoning. When faced with a property that doesn't fit neatly into standard valuation categories, a real estate licensee in British Columbia should first consider the comparative market analysis as the primary tool. This involves leveraging their local market knowledge and professional judgment to identify and adjust for the closest possible comparables. If sufficient comparable data is lacking, or if the property has unique income-generating or cost-intensive features, the income approach and cost approach can be used as supplementary methods to provide a broader perspective, but they should not replace the market-driven insights of a CMA. The licensee must always be able to justify their chosen valuation methods and the resulting opinion of value, ensuring it is objective, well-supported, and in the client's best interest, in accordance with RESA and the rules. Question 6. Risk assessment procedures indicate that general economic indicators suggest a potential shift in real estate market cycles across Canada. As a licensed real estate professional in British Columbia, how should you best advise a client who is considering selling their property in Vancouver within the next 6 months? Option A. Advise the client to sell immediately based on social media discussions suggesting an impending market crash, without further verification. Option B. Recommend the client postpone the sale indefinitely due to rumors of a broad market downturn, without assessing BC-specific conditions. Option C. Proactively research and analyze current and projected real estate market trends specific to British Columbia, particularly the Vancouver area, and synthesize this information to provide informed advice regarding the property's potential future value, marketability, and optimal timing for sale. Option D. Apply national real estate trend data directly to the client's Vancouver property, without investigating local market nuances or BC-specific economic factors. The correct answer is C. Proactively research and analyze current and projected real estate market trends specific to British Columbia, particularly the Vancouver area, and synthesize this information to provide informed advice regarding the property's potential future value, marketability, and optimal timing for sale. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate professional in British Columbia to interpret and act upon broad economic trends and their potential impact on the local market, while simultaneously adhering to their fiduciary duties to their client. The challenge lies in distinguishing between general market noise and actionable insights that directly affect a specific property's value and a client's investment strategy, all within the ethical and legal framework governing real estate practice in British Columbia. Misinterpreting these trends can lead to poor advice, financial loss for the client, and potential professional liability. Correct approach analysis. The best professional practice involves a real estate professional in British Columbia proactively researching and analyzing current and projected real estate market trends specific to British Columbia, particularly the local area of the property in question. This includes understanding factors like interest rate changes, economic growth projections, population shifts, and government policy impacts on the BC market. The professional must then synthesize this information to provide informed advice to their client regarding the property's potential future value, marketability, and optimal timing for sale or purchase. This approach aligns with the duty of care and skill owed to clients under British Columbia's real estate legislation and common law, ensuring advice is grounded in relevant market realities and professional expertise. Incorrect approach is analysis. Advising a client solely based on anecdotal evidence from social media discussions about real estate cycles, without cross-referencing with official economic data or BC-specific market reports, is professionally unacceptable. This fails to meet the standard of care required and relies on unreliable information, potentially leading to misguided decisions. Neglects the professional obligation to provide advice based on credible research and analysis. Recommending a client proceed with a sale or purchase immediately because of a general, unverified rumor of an impending market crash, without conducting specific due diligence on the British Columbia market conditions and the property's individual circumstances, is also professionally unsound. This approach prioritizes speculative fear over evidence-based analysis and ignores the need for a tailored strategy, potentially exposing the client to undue risk. Focusing exclusively on national real estate trends and applying them directly to a client's property in British Columbia without considering the unique economic drivers, regulatory environment, and specific market dynamics of BC is a significant professional failing. While national trends can be informative, local conditions often dictate market performance, and failing to account for these local nuances constitutes a breach of professional duty. Professional reasoning. Professionals should adopt a systematic approach to market analysis. This involves 1. Identifying the relevant jurisdiction, British Columbia, and its specific market characteristics. 2. Gathering data from credible sources, including government statistics, reputable real estate boards, economic forecasts, and industry reports relevant to BC. 3. Analyzing how broader economic cycles and trends might specifically impact the local BC market and the client's property. 4. Synthesizing this analysis into clear, actionable advice tailored to the client's individual goals and risk tolerance. 5. Continuously updating this analysis as market conditions evolve. Question 7. Risk assessment procedures indicate that a real estate licensee in British Columbia, while representing a buyer, discovers they have a close personal friendship with the seller of a property the buyer is interested in. What is the most appropriate and legally compliant course of action for the licensee to take immediately? Option A. Advise the buyer to seek alternative representation without disclosing the reason for the recommendation. Option B. Verbally inform the buyer about the personal relationship with the seller before any further negotiations commence. Option C. Immediately provide written disclosure to the buyer detailing the personal relationship with the seller. Option D. Proceed with the transaction, assuming the personal friendship will not influence negotiations or the buyer's decision. The correct answer is C. Immediately provide written disclosure to the buyer detailing the personal relationship with the seller. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a potential conflict of interest and requires the licensee to navigate the delicate balance between representing their client's best interests and adhering to the principles of fair dealing and disclosure mandated by the Real Estate Services Act, RESA, and its associated rules in British Columbia. The licensee must recognize that their personal relationship with the seller could influence their professional judgment and potentially impact the buyer's perception of fairness and transparency. Careful judgment is required to ensure all parties are treated ethically and legally. Correct approach analysis. The best professional practice involves the licensee immediately disclosing their personal relationship with the seller to the buyer in writing. This approach is correct because it directly addresses the potential conflict of interest by providing full transparency. Section 3-4 of the rules under RESA mandates that a licensee must disclose to all parties in a trade in real estate any personal or business relationship that the licensee has with any other party to the trade. This proactive disclosure allows the buyer to make an informed decision about whether they are comfortable proceeding with the licensee and ensures that the licensee is upholding their duty of honesty and integrity. Incorrect approaches analysis. One incorrect approach is to proceed with the transaction without disclosing the personal relationship, assuming it won't affect the negotiation. This is a failure to comply with Section 3-4 of the rules under RESA, which requires disclosure of such relationships. It breaches the duty of honesty and fair dealing owed to the buyer and could lead to a complaint, disciplinary action, and potential legal repercussions. Another incorrect approach is to only verbally inform the buyer about the relationship. While better than no disclosure, RESA and its rules emphasize written disclosure for significant matters like this. Verbal disclosure is difficult to prove and may not be considered sufficient by regulatory bodies, failing to meet the standard of clear and documented transparency required by the legislation. A further incorrect approach is to suggest the buyer find another agent without disclosing the reason. This avoids the immediate disclosure but does not address the underlying ethical obligation. It also potentially deprives the buyer of representation and fails to uphold the licensee's duty to act with integrity and disclose all material information that could affect the transaction or the parties' decisions. Professional reasoning. Professionals should adopt a framework of proactive disclosure and conflict avoidance. When a potential conflict of interest arises, the first step is to identify it. Then, assess the severity and the regulatory requirements for disclosure. The professional should always err on the side of over-disclosure rather than under-disclosure. Documenting all communications and disclosures is crucial. If the conflict is too significant to manage ethically, the professional should consider withdrawing from representing one or more parties, but only after ensuring proper disclosure and facilitating a smooth transition for the client. Question 8. Operational review demonstrates that a property in Vancouver, British Columbia, is being leased. The property includes a self-contained suite with its own entrance and separate utility meters, and the tenant intends to use it as their primary private residence. The landlord has provided a lease agreement that they drafted themselves, which includes clauses regarding rent increases and termination that differ from the standard provisions typically found in provincial tenancy forms. What is the most appropriate course of action for the real estate licensee representing the landlord? Option A. Advise the landlord that since the suite is self-contained with separate utilities, it falls under the Residential Tenancy Act, RTA of British Columbia, and therefore, the standard RTA tenancy agreement form must be used, with all terms compliant with the Act. Option B. Advise the landlord that because the suite has its own entrance and utilities, it is exempt from the RTA, and the drafted lease agreement is acceptable. Option C. Recommend that the landlord use their drafted lease agreement but advise them to modify the rent increase and termination clauses to align with the RTA while still using the custom document. Option D. Proceed with the landlord's drafted lease agreement, as the self-contained nature and separate utilities of the suite indicate it is a commercial lease, allowing for custom terms. The correct answer is A. Advise the landlord that since the suite is self-contained with separate utilities, it falls under the Residential Tenancy Act, RTA, of British Columbia, and therefore, the standard RTA tenancy agreement form must be used, with all terms compliant with the Act. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate licensee in British Columbia to navigate the complexities of lease agreements, specifically distinguishing between a residential tenancy agreement and a commercial lease, and understanding the implications of the Residential Tenancy Act, RTA, versus the common law governing commercial leases. Misclassifying the agreement can lead to significant legal and financial repercussions for both the landlord and the tenant, including potential disputes over rent, repairs, termination, and dispute resolution mechanisms. Careful judgment is required to ensure the correct legal framework is applied. Correct approach analysis. The best professional practice involves accurately identifying the nature of the property and the intended use by the tenant to determine the appropriate governing legislation. In British Columbia, if the property is intended to be occupied as a private residence by the tenant, it falls under the RTA, and the standard RTA lease agreement must be used. This approach is correct because it adheres strictly to the legal requirements of British Columbia for residential tenancies, ensuring tenant protections and landlord obligations are clearly defined according to provincial statute. Using the RTA form is mandatory for residential tenancies, and deviating from it can render certain clauses unenforceable and lead to disputes. Incorrect approach is analysis. One incorrect approach is to assume that any lease agreement for a property with a separate entrance and utilities automatically constitutes a commercial lease, regardless of its primary use. This fails to recognize that the RTA applies to any tenancy where a tenant occupies a residential unit as their home, even if it has some commercial characteristics or is a secondary suite. The RTA's definition of a rental unit is broad and focuses on residential occupation. Another incorrect approach is to use a standard commercial lease template for a property that is clearly intended to be a private residence for the tenant, simply because the landlord desires more flexibility than the RTA typically offers. This is a direct contravention of the RTA, which is designed to provide specific protections for residential tenants. Such a lease would likely be deemed void in whole or in part, and the landlord could be subject to penalties. A further incorrect approach is to draft a lease agreement that attempts to contract out of the RTA's provisions for a residential tenancy. The RTA explicitly prohibits contracting out of its provisions that benefit the tenant. Any attempt to do so would render those specific clauses invalid, and the tenancy would still be governed by the RTA. Professional reasoning. Professionals should always begin by understanding the intended use of the property. If the property is to be occupied as a dwelling, the licensee must apply the RTA. This involves using the prescribed RTA tenancy agreement form and ensuring all terms comply with the Act. If the property is intended for commercial purposes, then common law principles and potentially other specific commercial leasing legislation would apply, and a custom commercial lease agreement would be appropriate. When in doubt, licensees should consult with legal counsel specializing in real estate law in British Columbia to ensure compliance. Question 9. Quality control measures reveal that a real estate licensee in British Columbia is advising a client whose property value has been impacted by a recent economic downturn. The licensee is considering how to best guide their client through this challenging market. Which of the following approaches best aligns with regulatory requirements and professional ethics in British Columbia? Option A. Advise the client to immediately list their property at a significantly reduced price to beat the market crash, without a detailed comparative market analysis or consideration of the client's specific needs. Option B. Recommend that the client delay listing their property indefinitely until the market fully recovers, regardless of the client's personal financial situation or urgency to sell. Option C. Proactively educate the client about current market conditions, contributing factors, potential future trends based on objective data, and discuss how these factors might influence their selling decision, empowering them to make an informed choice based on their personal circumstances. Option D. Emphasize only the negative aspects of the market downturn and the high risks of selling now, without exploring any potential strategies or alternative options for the client. The correct answer is C. Proactively educate the client about current market conditions, contributing factors, potential future trends based on objective data, and discuss how these factors might influence their selling decision, empowering them to make an informed choice based on their personal circumstances. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a real estate licensee in British Columbia to navigate the complexities of market fluctuations and their impact on client advice, while adhering strictly to the Real Estate Services Act, RESA, and its associated rules. The licensee must balance providing informed guidance with avoiding misrepresentation or undue influence. Ensuring client interests are paramount. The economic downturn creates a sensitive environment where clients may be anxious or make decisions based on fear, necessitating a high degree of ethical conduct and regulatory compliance. Correct approach analysis. The best professional practice involves a licensee proactively educating their client about the current market conditions in British Columbia, including the factors contributing to the downturn and potential future trends, based on objective data and reputable sources. This approach aligns with the duty of care owed to clients under RSA, which mandates licensees to act with reasonable skill and care, and to promote and protect the best interests of their clients. Providing a balanced perspective, outlining both risks and potential opportunities, and empowering the client to make an informed decision based on their personal financial situation and goals is crucial. This also upholds the ethical obligation to provide accurate and timely information without misrepresentation. Incorrect approaches analysis. Advising the client to immediately list their property at a significantly reduced price to beat the market crash, without a thorough analysis of comparable properties and the client's specific circumstances, is a failure to exercise reasonable skill and care. This approach risks misrepresenting the market value and could lead to the client accepting an offer below what might be achievable with a more nuanced strategy, potentially violating the duty to promote and protect the client's best interests. Suggesting the client delay listing their property indefinitely until the market fully recovers, without considering the client's individual needs or the potential for further market decline, is also problematic. This approach may not be in the client's best interest if they have a pressing need to sell, or if the market recovery is uncertain or prolonged. It also fails to provide proactive guidance based on current realities, focusing solely on the negative aspects of the market downturn and emphasizing the high risk of selling now, without presenting any potential strategies or alternative options, could be seen as unduly influencing the client's decision or failing to provide comprehensive advice. While acknowledging risks is important, a complete picture that includes potential solutions or alternative approaches is necessary for informed decision-making. Professional reasoning. Professionals in British Columbia should adopt a decision-making framework that prioritizes client interests and regulatory compliance. This involves 1. Thoroughly understanding the current market dynamics and economic factors affecting real estate in British Columbia. 2. Gathering objective data and market analysis to inform advice. 3. Communicating this information clearly and comprehensively to the client, explaining both the risks and potential opportunities. 4. Discussing the client's individual financial situation, goals, and risk tolerance. 5. Collaboratively developing a strategy that best meets the client's needs, while ensuring all advice is truthful, accurate, and not misleading, in accordance with RSA and its rules. Question 10. The performance metrics show that a buyer in British Columbia is interested in purchasing a property for $750,000. They have $100,000 saved for a down payment and plan to use the equity from selling their current home, which they estimate will net them $250,000 after all selling costs. The buyer's current mortgage balance is $300,000. They have secured a pre-approval for a mortgage of $550,000. Assuming the new property requires a 20% down payment to avoid mortgage default insurance premiums, and considering the buyer's existing mortgage and estimated net sale proceeds, what is the minimum additional cash the buyer would need to have available at closing to meet the 20% down payment requirement and cover estimated closing costs of $15,000 for the new property, without relying on the pre-approved mortgage amount for the down payment itself? Option A, $35,000. Option B, $10,000. Option C, $0. Option D, $25,000. Correct answer is B, $10,000. Explanation. Scenario analysis. This scenario presents a common challenge in real estate financing where a buyer's ability to secure a mortgage is contingent on the sale of their current property. The professional challenge lies in accurately advising the buyer on the financial implications and potential risks associated with such a conditional offer, ensuring compliance with the Real Estate Services Act (RESA) and its associated rules, particularly concerning disclosure and professional conduct. Mismanagement of this situation could lead to a breach of fiduciary duty, misrepresentation, and potential legal repercussions for the licensee and their brokerage. Correct approach analysis. The best professional practice involves a thorough calculation of the buyer's financial capacity, considering all relevant costs and potential shortfalls. This includes not only the down payment but also closing costs, carrying costs for both properties if applicable, and a buffer for unforeseen expenses. The licensee must then clearly and comprehensively disclose these financial projections and risks to the buyer in writing. This approach aligns with the licensee's duty to act in the best interest of the client, provide competent service, and ensure informed consent, as mandated by RISA and the rules. Specifically, Rule 5-1 of the rules under RISA requires licensees to act with reasonable care and skill, and to disclose all material information. This includes providing accurate financial advice and projections to enable the client to make an informed decision. Incorrect approaches analysis. One incorrect approach involves simply accepting the buyer's stated down payment amount without verifying its sufficiency or considering the sale of their current property. This fails to meet the standard of care required by RISA and the rules, as it neglects to perform due diligence on the buyer's financial capacity and the feasibility of the transaction. It could lead to the buyer being unable to complete the purchase, resulting in financial loss and potential legal action. Another incorrect approach is to advise the buyer that the offer is financially sound solely based on the purchase price and the buyer's current equity in their existing home, without accounting for the sale proceeds, closing costs on both transactions, and potential delays in selling the current property. This constitutes a misrepresentation of financial advice and a failure to disclose material risks, violating the licensee's fiduciary duty and the requirements of RISA. A third incorrect approach is to proceed with the offer without a clear understanding of the buyer's ability to cover the mortgage payments and associated costs for the new property, even if the current property sells. This demonstrates a lack of professional diligence and a failure to adequately assess the buyer's financial position, potentially leading to a situation where the buyer defaults on their obligations. This directly contravenes the obligation to provide competent service and act in the client's best interest under RISA. Professional reasoning. Professionals should adopt a systematic approach to financial assessments in real estate transactions. This involves 1. Understanding the client's financial goals and constraints. 2. Performing detailed calculations, including all potential income, expenses, and liabilities. 3. Identifying and quantifying all risks, such as market fluctuations, financing contingencies, and sale contingencies. 4. Clearly communicating these findings and risks to the client in writing, ensuring they understand the implications before making any commitments. 5. Documenting all advice and client decisions. This structured process ensures regulatory compliance, upholds ethical standards, and protects both the client and the licensee. Question 11. Governance review demonstrates that a property in rural British Columbia features a detached dwelling, extensive cultivated fields used for commercial crop production, and facilities for raising livestock. The owner also operates a small on-site processing facility for their produce. Based on the primary use and characteristics, how should this property be classified for real estate purposes in British Columbia? Option A. Primarily as residential due to the presence of a detached dwelling for habitation. Option B. Primarily as agricultural, considering the significant land use for cultivation and livestock, and the on-site processing directly related to these activities. Option C. Primarily as industrial, given the presence of a processing facility for agricultural products. Option D. Primarily as commercial, because the farming activities generate income and include on-site processing. The correct answer is B. Primarily as agricultural, considering the significant land use for cultivation and livestock, and the on-site processing directly related to these activities. Explanation. Scenario analysis. This scenario presents a professional challenge due to the potential for misclassification of a property, which can lead to significant legal, financial, and ethical repercussions for the real estate professional. Misunderstanding the distinct characteristics and intended uses of different property types, as defined by British Columbia's real estate regulations and common practice, can result in incorrect advice to clients, improper marketing, and potential breaches of professional conduct. Accurate identification is crucial for compliance with zoning bylaws, disclosure requirements, and for ensuring the property is marketed to the appropriate buyer pool. Correct approach analysis. The best professional approach involves meticulously examining the primary use and characteristics of the property in question, aligning it with the definitions and typical features of each real estate category under British Columbia's framework. This means identifying whether the property's dominant purpose is for human habitation, residential, for business operations and services, commercial, for manufacturing or storage, industrial, or for cultivation and animal husbandry, agricultural, for property with a detached dwelling and a significant portion of land dedicated to growing crops and raising livestock. The primary classification would lean towards agricultural, provided the scale and intent align with the definition of agricultural land use in British Columbia, potentially requiring consideration of the Agricultural Land Reserve, ALR, regulations. This detailed, use-based analysis ensures accurate representation and compliance. Incorrect approaches analysis. One incorrect approach is to classify the property solely based on the presence of a dwelling, labeling it as residential. This fails to acknowledge the substantial agricultural operations, ignoring a key defining characteristic and potentially misleading buyers interested in farming. This approach disregards the primary economic activity and land use, which is a critical factor in property classification. Another incorrect approach is to categorize the property as commercial simply because there is an income-generating aspect through farming. While some agricultural operations might have commercial elements, the fundamental nature of the land use for cultivation and livestock is distinct from typical commercial ventures like retail or office spaces. This broad categorization overlooks the specific regulatory and market considerations for agricultural properties. A further incorrect approach is to label the property as industrial due to the processing or storage of agricultural products. While industrial activities can be related to agriculture, the core definition of industrial property focuses on manufacturing, processing, or warehousing of goods, not directly tied to the primary cultivation or raising of animals on the land itself. This misclassification fails to recognize the land's primary agricultural purpose. Professional reasoning. Professionals should adopt a systematic approach to property classification. This involves understanding the definitions of residential, commercial, industrial, and agricultural properties as they apply within British Columbia. Key considerations include the primary use of the land and any structures, the zoning bylaws applicable to the property, and the client's stated intentions for the property. When in doubt, especially with properties that exhibit characteristics of multiple categories, professionals should consult relevant municipal bylaws, provincial regulations, such as those pertaining to the Agricultural Land Reserve, and potentially seek expert advice to ensure accurate classification and avoid misrepresentation. Question 12. Benchmark analysis indicates that a real estate brokerage in British Columbia is experiencing challenges in maintaining up-to-date and accurate financial records for its client trust accounts. Considering the regulatory framework governing real estate transactions in British Columbia, which of the following approaches best ensures compliance with financial management, reporting, and record-keeping requirements? Option A. Reconcile trust accounts only when a client requests a statement or when a regulatory audit is imminent. Option B. Delegate the reconciliation process to an unlicensed administrative assistant without adequate oversight or a robust internal review process. Option C. Establish a documented internal policy for daily reconciliation of all trust account transactions and generate comprehensive monthly trust account reconciliation statements. Option D. Rely solely on the bank's monthly statement to verify trust account balances without performing an independent reconciliation. The correct answer is C. Establish a documented internal policy for daily reconciliation of all trust account transactions and generate comprehensive monthly trust account reconciliation statements. Explanation. Scenario analysis. This scenario presents a common challenge in real estate financial management, balancing the need for timely and accurate financial reporting with the practicalities of managing multiple client trust accounts. The professional challenge lies in ensuring that all financial transactions are meticulously recorded and reported in accordance with the Real Estate Services Act (RESA) and its associated rules, while also maintaining operational efficiency. Failure to do so can lead to breaches of trust, regulatory penalties, and damage to professional reputation. Careful judgment is required to implement a system that is both compliant and effective. Correct approach analysis. The best professional practice involves establishing a clear, documented internal policy for the reconciliation of all trust account transactions on a daily basis and generating comprehensive monthly trust account reconciliation statements. This approach directly addresses the requirements of the RSA and the rules, which mandate accurate record keeping and timely reporting to clients and the Real Estate Services Board (RESB). Daily reconciliation ensures that any discrepancies are identified and corrected promptly, minimizing the risk of errors and unauthorized transactions. Monthly statements provide clients with a clear and detailed overview of their funds, fulfilling reporting obligations and fostering transparency. This proactive and systematic method ensures compliance and builds client confidence. Incorrect approaches analysis. One incorrect approach involves reconciling trust accounts only when a client requests a statement or when a regulatory audit is imminent. This fails to meet the daily reconciliation requirement and the spirit of timely reporting mandated by RSA. It creates a significant risk of undetected errors or misappropriation of funds, as discrepancies might go unnoticed for extended periods. This reactive approach is a clear violation of regulatory expectations for diligent financial management. Another incorrect approach is to rely solely on the bank's monthly statement to verify trust account balances without performing an independent reconciliation. Bank statement only reflects the bank's records and does not account for all transactions that may have occurred within the brokerage trust account, such as outstanding checks or deposits in transit. This method is insufficient for ensuring the accuracy and completeness of the brokerage's financial records as required by RSA and the rules, and it bypasses the essential step of internal verification. A further incorrect approach is to delegate the reconciliation process to an unlicensed administrative assistant without adequate oversight or a robust internal review process. While administrative staff can assist with data entry, the ultimate responsibility for the accuracy and compliance of trust account management rests with the licensed real estate professional. Without proper supervision and a clear understanding of regulatory requirements, this delegation can lead to errors and non-compliance, as the assistant may not be aware of or equipped to handle the specific legal and ethical obligations associated with trust funds in British Columbia. Professional reasoning. Professionals should adopt a proactive and systematic approach to financial management. This involves understanding the specific regulatory requirements of the Real Estate Services Act and its rules in British Columbia. Developing and adhering to clear internal policies and procedures for trust account management, including daily reconciliation and monthly reporting, is paramount. Regular training and ongoing professional development in financial management best practices are also essential. When faced with financial management tasks, professionals should always prioritize compliance, accuracy, and transparency, ensuring that client funds are handled with the utmost care and integrity. Question 13. Compliance review shows that a real estate licensee in British Columbia is handling a transaction where the lender requires the buyer to obtain private mortgage insurance, PMI. Which of the following approaches best reflects the licensee's professional obligations and ensures client understanding regarding PMI? Option A. Minimize the discussion around PMI, referring to it as a minor administrative detail that the lender requires, without detailing its cost or implications for the buyer. Option B. Inform the client that the licensee can potentially negotiate or waive the PMI requirement with the lender to reduce the buyer's overall costs. Option C. Present PMI as a mandatory fee that the licensee will arrange as part of the transaction, without elaborating on its specific purpose or who benefits from the insurance. Option D. Clearly explain to the client that private mortgage insurance is a lender requirement to protect the lender's risk, detailing its purpose, typical cost, and that it is a condition of the mortgage, ensuring the client understands it is not a service provided by the licensee. The correct answer is D. Clearly explain to the client that private mortgage insurance is a lender requirement to protect the lender's risk, detailing its purpose, typical cost, and that it is a condition of the mortgage, ensuring the client understands it is not a service provided by the licensee. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a real estate licensee in British Columbia to navigate the complexities of private mortgage insurance, PMI, in a way that is both compliant with the Real Estate Services Act, RSA, and the associated rules, and ethically sound in protecting the client's interests. The challenge lies in ensuring the client fully understands the implications of PMI, particularly concerning their financial obligations and the lender's security, without misrepresenting the product or creating undue pressure. Accurate disclosure and informed consent are paramount. Correct approach analysis. The best professional practice involves clearly and comprehensively explaining to the client that private mortgage insurance is a requirement imposed by the lender to mitigate their risk, not a service provided by the real estate licensee. This explanation should detail what PMI covers, protecting the lender, not the borrower, the typical cost structure, often a premium added to the mortgage, and the fact that it is a condition of obtaining the mortgage. This approach is correct because it aligns with the licensee's duty of care and disclosure obligations under RSA and the rules, ensuring the client makes an informed decision about their mortgage financing. It prioritizes client understanding and transparency regarding a significant financial component of their transaction. Incorrect approaches analysis. One incorrect approach is to present PMI as a mandatory fee that the licensee is responsible for arranging, without fully explaining its purpose and who it benefits. This is professionally unacceptable as it misrepresents the nature of PMI and could lead the client to believe the licensee is providing a service for which they might be compensated, or that the fee is for the licensee's benefit. This fails to uphold the duty of disclosure and could be construed as a conflict of interest if the licensee benefits from the arrangement without full disclosure. Another incorrect approach is to downplay the significance or cost of PMI, suggesting it is a minor administrative detail. This is ethically problematic as it omits crucial information that directly impacts the client's financial commitment. RSA and the rules require licensees to provide all material information relevant to a transaction, and the cost and purpose of PMI are material. Failing to do so undermines the client's ability to make an informed decision and could lead to financial hardship or dissatisfaction later. A third incorrect approach is to imply that the licensee can negotiate or waive the PMI requirement. This is professionally unacceptable because PMI is a lender-imposed condition, and the real estate licensee has no authority to alter or waive it. Misrepresenting this authority is a serious breach of professional conduct and could lead to significant legal and disciplinary consequences. It also creates false expectations for the client. Professional reasoning. Professionals should always prioritize clear, accurate, and comprehensive disclosure to their clients. When dealing with financial products or requirements like PMI, it is essential to explain the purpose, cost, and beneficiary of such products. The licensee's role is to facilitate the transaction and ensure the client is fully informed, not to act as a financial advisor or to misrepresent the terms of third-party agreements like mortgage insurance. A robust decision-making process involves asking, am I providing all necessary information for my client to make an informed decision? And is my conduct transparent and in the best interest of my client, consistent with regulatory requirements? Question 14. The audit findings indicate that a real estate professional in British Columbia, when advising a client interested in acquiring an investment property, presented financing options. The client expressed a need for rapid funding, but also a desire for potentially flexible repayment terms. The professional discussed hard money loans and seller financing. Which of the following approaches best reflects professional and regulatory compliance in British Columbia? Option A. The professional presented both hard money loans and seller financing as equally viable and simple options, focusing on the potential for quick acquisition without delving into the specific risks, costs, and legal implications of each. Option B. Professional emphasized that seller financing is always a more advantageous option for investors due to its perceived flexibility, without thoroughly explaining the potential for less favorable terms or the need for independent legal review of the seller's financing agreement. Option C. The professional highlighted the speed of funding associated with hard money loans as the primary benefit, downplaying the higher interest rates and shorter repayment terms, and suggested it was the most suitable option given the client's urgency. Option D. The professional provided a detailed explanation of both hard money loans and seller financing, outlining the typical interest rates, fees, repayment structures, and the inherent risks and benefits of each, and strongly advised the client to consult with an independent legal professional and a financial advisor before making any decisions. The correct answer is D. The professional provided a detailed explanation of both hard money loans and seller financing, outlining the typical interest rates, fees, repayment structures, and the inherent risks and benefits of each, and strongly advise the client to consult with an independent legal professional and a financial advisor before making any decisions. Explanation: the audit findings indicate a potential misrepresentation of financing options to a client in British Columbia, specifically concerning hard money loans and seller financing. This scenario is professionally challenging because it requires a real estate professional to accurately explain complex financing structures, their associated risks and benefits, and to ensure the client fully understands their implications before making a decision. The challenge lies in balancing the client's desire for quick or flexible financing with the professional's duty to act in the client's best interest, providing unbiased and comprehensive advice. The correct approach involves the real estate professional thoroughly explaining both hard money loans and seller financing, detailing the typical terms, interest rates, fees, repayment schedules, and the potential for higher costs and risks associated with hard money loans. Crucially, this approach emphasizes advising the client to seek independent legal and financial advice before committing to either option. This is correct because under the Real Estate Services Act (RESA) of British Columbia and its associated rules, real estate professionals have a fiduciary duty to their clients. This duty includes providing honest, fair, and competent service, disclosing all material facts, and avoiding misrepresentation. Recommending independent professional advice is a cornerstone of ethical practice, ensuring the client is fully informed and protected, especially when dealing with non-traditional financing that carries significant risks. An incorrect approach would be to downplay the risks of a hard money loan, focusing solely on its speed of funding, without adequately explaining the higher interest rates, shorter terms, and potential for foreclosure if repayment terms are not met. This failure to disclose material risks violates the duty of honesty and fair dealing under RESA. Another incorrect approach would be to present seller financing as a universally beneficial option, without exploring the potential for the seller to impose unfavorable terms or for the client to be locked into a loan structure that may not be in their long-term financial interest. This constitutes a failure to provide competent service and to act in the client's best interest. Finally, an approach that steers the client towards a specific financing option without a balanced presentation of all relevant information and without recommending independent advice is ethically unsound and potentially breaches RESA requirements for disclosure and client protection. Professional decision-making in such situations requires a structured approach. First, identify the client's needs and objectives. Second, research and understand all available financing options, including their pros and cons. Third, present these options clearly and comprehensively, ensuring the client understands the risks and benefits of each. Fourth, strongly recommend seeking independent legal and financial advice. And fifth, document all advice given and received. Question 15. The efficiency study reveals that a real estate licensee in British Columbia, while representing a buyer, has a close personal relationship with the owner of a property the buyer is interested in purchasing. What is the most appropriate course of action for the licensee to take to uphold their professional obligations? Option A. Inform the buyer that they have a connection to the seller, but downplay its significance, assuring the buyer that their best interests will still be prioritized. Option B. Immediately disclose the personal relationship to the buyer, explain how it might influence their advice, and offer the buyer the option to continue with the licensee or seek alternative representation. Option C. Seek a verbal agreement from the buyer that they are comfortable with the licensee continuing to represent them, without providing a detailed explanation of the potential conflict. Option D. Proceed with the transaction, assuming they can remain impartial, and focus on securing the best possible deal for the buyer. The correct answer is B. Immediately disclose the personal relationship to the buyer, explain how it might influence their advice, and offer the buyer the option to continue with the licensee or seek alternative representation. Explanation. The efficiency study reveals a potential conflict of interest scenario that is professionally challenging because it requires a real estate licensee to navigate competing loyalties and obligations. In British Columbia, real estate licensees owe fiduciary duties to their clients, which include the duty of loyalty and the duty to avoid conflicts of interest. The Real Estate Services Act (RESA) and the rules under RESA are designed to protect consumers and maintain the integrity of the real estate profession by establishing clear standards of conduct. A licensee must act in the best interests of their client at all times and disclose any potential conflicts that could compromise this duty. The correct approach involves immediate and full disclosure to the client. This means informing the client about the potential conflict of interest, explaining how it might affect the licensee's ability to act solely in the client's best interest, and offering the client the option to continue with the licensee or seek alternative representation. This aligns with the ethical obligations under RSA to act with honesty and integrity, and to avoid situations where personal interests could influence professional judgment. Specifically, Rule 3-3 of the rules under RSA mandates disclosure of any interest a licensee has in a trade, and this extends to situations where a licensee's actions might benefit another party in a way that could be detrimental to their client. An incorrect approach would be to proceed with the transaction without full disclosure, assuming the licensee can remain impartial. This violates the duty of loyalty and the obligation to avoid conflicts of interest, as the licensee's personal gain or the gain of an associate could inadvertently influence their advice or actions. Another incorrect approach is to downplay the significance of the conflict to the client. This is a misrepresentation and a failure to provide the client with the necessary information to make an informed decision about their representation, thereby breaching RSA requirements for transparency and fair dealing. Finally, attempting to resolve the conflict by solely relying on the client's verbal consent without providing a clear explanation of the implications and offering alternatives is also insufficient. Professional practice demands a proactive and transparent approach to managing conflicts, ensuring the client's interests are paramount and that they have the agency to decide how to proceed. Professional reasoning in such situations requires a proactive approach to identifying potential conflicts, a thorough understanding of the disclosure obligations under RSA, and a commitment to prioritizing client interests. When a potential conflict arises, licensees should err on the side of caution and disclose it, providing the client with all necessary information to make an informed decision. Question 16. Stakeholder feedback indicates that real estate licensees in British Columbia sometimes encounter situations where they wish to represent both the seller and the buyer in the same property transaction. Considering the regulatory framework and ethical obligations under British Columbia law, which of the following represents the most appropriate and legally compliant course of action for a licensee in such a scenario? Option A. Obtain written informed consent from both the seller and the buyer after fully disclosing the potential conflicts of interest and limitations inherent in dual agency, and then proceed with strict adherence to impartiality and fairness. Option B. Proceed with representing both parties, assuming that their interests are aligned, and that no formal disclosure is necessary as long as the transaction is completed successfully. Option C. Prioritize the interests of the party with whom the licensee has a longer-standing relationship, without explicitly informing the other party of this prioritization. Option D. Decline to represent either party and advise them to seek separate legal counsel, even if both parties express a desire for the licensee to represent them both. The correct answer is A. Obtain written informed consent from both the seller and the buyer after fully disclosing the potential conflicts of interest and limitations inherent in dual agency, and then proceed with strict adherence to impartiality and fairness. Explanation. This scenario presents a professional challenge due to the inherent conflict of interest that arises when a real estate licensee attempts to represent both the seller and the buyer in the same transaction in British Columbia. Navigating this situation requires a deep understanding of the Real Estate Services Act, RSA, and its associated rules, as well as the ethical obligations of licensees to their clients. The core difficulty lies in fulfilling the fiduciary duties owed to both parties simultaneously, which can be compromised when their interests diverge. The best professional approach involves obtaining informed consent from both parties to act as a dual agent, clearly outlining the limitations and potential conflicts. This requires a comprehensive disclosure process, ensuring both the seller and the buyer fully understand that the licensee's ability to advocate for each party's individual best interests may be restricted. The licensee must then proceed with utmost care, maintaining neutrality and fairness while facilitating the transaction. This approach aligns with the principles of RSA and the rules, which permit dual agency under strict conditions of disclosure and consent, aiming to protect consumers while allowing for efficient transactions when parties agree to such an arrangement. An incorrect approach would be to proceed with representing both parties without full disclosure and informed consent. This failure to inform and obtain agreement violates the licensee's duty of honesty and integrity, as well as specific disclosure requirements under RSA. It creates a situation where one or both parties are not aware of the potential conflicts, undermining the trust essential to the agency relationship and potentially leading to a breach of fiduciary duty. Another incorrect approach is to prioritize the interests of one party over the other, without explicit agreement or disclosure. For instance, if a licensee, acting as a dual agent, subtly steers the buyer towards accepting a higher price or the seller towards accepting a lower offer to expedite the deal, this constitutes a breach of their duty to the disadvantaged party. This action directly contravenes the requirement for impartiality and fair dealing inherent in dual agency and is a violation of RSA. Finally, attempting to represent both parties without understanding or adhering to the specific disclosure and consent requirements for dual agency in British Columbia is also professionally unacceptable. This demonstrates a lack of diligence and a failure to comply with regulatory obligations, potentially exposing the licensee to disciplinary action and jeopardizing the transaction. Professionals should approach such situations by first recognizing the potential for conflict. They must then consult the relevant legislation and rules governing agency relationships in British Columbia. The decision-making process should prioritize transparency, informed consent, and the ability to act impartially. If the complexities of dual agency cannot be managed ethically and legally, the professional should decline to act as a dual agent and recommend that each party seek independent representation. Question 17. Benchmark analysis indicates that a landlord in British Columbia wishes to end a tenancy agreement for their own use. What is the legally compliant and procedurally correct first step the landlord must take to initiate this eviction process under the Residential Tenancy Act? Option A. Serve the tenant with a formal notice to end tenancy for landlord's use, specifying the grounds and providing the required notice period. Option B. Inform the tenant verbally that they must vacate the premises within 30 days. Option C. Change the locks to the rental unit to prevent the tenant from re-entering. Option D. Issue a notice to the tenant citing general dissatisfaction with their tenancy as the reason for eviction. The correct answer is A. Serve the tenant with a formal notice to end tenancy for landlord's use, specifying the grounds and providing the required notice period. Explanation. Scenario analysis. This scenario presents a common challenge for property managers and landlords in British Columbia, navigating the legal complexities of tenant eviction while adhering strictly to the Residential Tenancy Act, RTA. The professional challenge lies in balancing the landlord's right to regain possession of the property with the tenant's statutory rights and protections. Misinterpreting or misapplying the RTA can lead to significant legal repercussions, including financial penalties, protracted legal battles, and the invalidation of eviction notices. Careful judgment is required to ensure all procedural steps are followed precisely, and that the grounds for eviction are legally sound and well documented. Correct approach analysis. The best professional practice involves initiating the eviction process by serving the tenant with a proper notice to end tenancy for a landlord's use, clearly specifying the grounds for eviction as outlined in Section 49 of the Residential Tenancy Act. This notice must be in the prescribed form, accurately state the reason for the landlord's use, e.g., moving in themselves or a close family member, and provide the tenant with the required notice period as stipulated by the RTA. This approach is correct because it directly aligns with the legal framework established by the RTA for landlord's use evictions, ensuring procedural fairness for the tenant and establishing a legally defensible position for the landlord. It respects the tenant's right to adequate notice and a clear understanding of the reason for termination. Incorrect approach is analysis. Failing to serve a formal notice to end tenancy and instead relying on a verbal agreement or informal communication with the tenant to vacate is a significant regulatory failure. The RTA mandates written notice for all evictions, and informal arrangements are not legally binding or enforceable. This approach bypasses crucial tenant protections and can lead to disputes that are difficult to resolve through the residential tenancy branch. Attempting to evict the tenant by changing the locks or removing their belongings without a court order or a valid notice to end tenancy and subsequent order from the residential tenancy branch is an illegal act. This constitutes a landlord's self-help eviction, which is strictly prohibited under British Columbia law and carries severe penalties, including substantial fines and potential liability for damages to the tenant. Serving a notice to end tenancy with vague or unsubstantiated reasons for landlord's use, or for reasons not permitted under Section 49 of the RTA, is also a regulatory failure. The RTA requires specific and legitimate grounds for landlord's use evictions. A notice that does not meet these criteria is invalid and will be dismissed by the residential tenancy branch, requiring the landlord to restart the eviction process. Professional reasoning. Professionals should always consult the most current version of the Residential Tenancy Act and its regulations when dealing with eviction matters. When considering an eviction for landlord's use, the first step is to confirm that the intended use is a valid ground under Section 49 of the RTA. If it is, the next critical step is to obtain and correctly complete the prescribed notice to end tenancy form, ensuring all details are accurate and the correct notice period is provided. It is advisable to seek legal counsel or consult with the residential tenancy branch if there is any uncertainty regarding the process or the validity of the grounds for eviction. Documentation is paramount. All communications and notices should be in writing and kept as records. Question 18. Benchmark analysis indicates that a licensed real estate professional in British Columbia is facing a busy period with multiple client transactions closing simultaneously. While managing these urgent client needs, they realize their mandatory continuing education requirements for license renewal are approaching their deadline. What is the most prudent course of action to ensure continued compliance with the Real Estate Council of British Columbia's regulations? Option A. Postpone continuing education until after the current wave of client transactions concludes, planning to complete the hours in a compressed timeframe before the absolute final deadline. Option B. Assume that the Real Estate Council of British Columbia will grant an extension for continuing education if the licensee communicates their busy client schedule. Option C. Rely on informal assurances from other real estate professionals in British Columbia regarding the leniency of continuing education deadlines during peak business periods. Option D. Immediately schedule and complete the required continuing education courses, even if it means temporarily adjusting client meeting schedules or delegating less critical tasks to administrative staff. The correct answer is D. Immediately schedule and complete the required continuing education courses, even if it means temporarily adjusting client meeting schedules or delegating less critical tasks to administrative staff. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate professional in British Columbia to navigate the nuances of licensing renewal and continuing education requirements while managing a demanding workload. The pressure of client commitments can create a temptation to prioritize immediate business over regulatory compliance, which can have serious consequences. Careful judgment is required to balance professional responsibilities with legal obligations. Correct approach analysis. The best professional practice involves proactively identifying and fulfilling all licensing and continuing education requirements well in advance of deadlines. This approach ensures that a licensee remains in good standing with the Real Estate Council of British Columbia (REC) and can continue to practice legally. Specifically, this means understanding the REC stipulated continuing education hours, the types of approved courses, and the renewal process, and then scheduling time to complete these obligations without compromising client service. This proactive stance is mandated by the Real Estate Services Act and REC rules, which place the onus on the licensee to maintain their license and professional development. Incorrect approaches analysis. One incorrect approach is to assume that a temporary lapse in completing continuing education hours will be overlooked by the REC, especially if the licensee intends to catch up later. This is a direct violation of the REC continuing education requirements, which are mandatory for license renewal. Failure to meet these requirements can lead to disciplinary action, including fines or suspension of the license. Another incorrect approach is to rely on informal advice from colleagues about the flexibility of continuing education deadlines. While peer advice can be helpful, it is not a substitute for understanding and adhering to the official regulations set forth by the REC. Relying on such advice can lead to a misunderstanding of the strict compliance obligations and potentially result in noncompliance. A further incorrect approach is to prioritize client-facing activities to the exclusion of all administrative and professional development tasks, believing that business success will somehow mitigate any regulatory oversights. This demonstrates a failure to recognize that maintaining a valid license is a prerequisite for conducting any real estate business in British Columbia. The Real Estate Services Act clearly states that licensees must be licensed at all times they are providing real estate services. Professional reasoning. Professionals should adopt a systematic approach to managing their licensing and continuing education obligations. This involves creating a personal compliance calendar that tracks all deadlines for license renewal and continuing education. Regular review of the REC website and official communications is essential to stay informed of any changes to regulations. Furthermore, licensees should allocate dedicated time for professional development, treating it with the same importance as client appointments. When faced with competing demands, the licensee must prioritize regulatory compliance, as it is the foundation upon which their ability to serve clients is built. Question 19. Process analysis reveals that a real estate agent in British Columbia has successfully found a buyer for a property listed by another brokerage. The agent also has a client who is interested in purchasing this specific property. What is the most appropriate course of action for the agent to take to ensure compliance with British Columbia's real estate regulations and ethical standards? Option A. Prioritize the seller's interest by focusing on achieving the highest possible sale price, as this is the primary duty of a listing agent. Option B. Obtain informed written consent from both the seller and the buyer to act as a dual agent, clearly outlining the limitations and responsibilities of this role, and then proceed with impartiality. Option C. Proceed with the transaction without explicitly informing both parties about the dual agency, assuming that their mutual interest in completing the sale implies consent. Option D. Focus on securing the best possible terms for the buyer, as the agent's primary relationship is with the buyer who engaged them to find a property. The correct answer is B. Obtain informed written consent from both the seller and the buyer to act as a dual agent, clearly outlining the limitations and responsibilities of this role, and then proceed with impartiality. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate agent in British Columbia due to the inherent conflict of interest that arises when a licensee represents both the buyer and the seller in the same transaction. Navigating this dual agency requires strict adherence to regulatory requirements and ethical obligations to ensure fairness and transparency for both parties. Failure to do so can lead to significant legal and professional repercussions. Correct approach analysis. The best professional practice involves obtaining informed consent from both parties for dual agency and clearly outlining the limitations and responsibilities involved. In British Columbia, this is governed by the Real Estate Services Act and its associated rules. Specifically, licensees must disclose their intention to act as a representative for both parties and obtain written consent from each party before proceeding. This consent must acknowledge that the licensee owes a duty of loyalty to both parties, which may be compromised, and that the licensee cannot act exclusively for either party. The licensee must then act impartially and avoid favoring one party over the other, ensuring all material information is disclosed to both. This approach upholds the principles of transparency, fairness, and fiduciary duty as mandated by the regulatory framework. Incorrect approaches analysis. Acting solely in the best interest of the seller, despite also representing the buyer, is a failure to uphold the duty of impartiality required in dual agency. This violates the principles of fair dealing and misrepresentation, as the licensee is not acting in the best interest of all parties involved, contrary to the disclosure and consent obtained. Prioritizing the buyer's interests and withholding material information about the property's condition from the seller is also a breach of regulatory obligations. While the licensee must disclose material information to the buyer, they also have a duty to disclose material information to the seller, especially if it impacts the transaction's fairness or the seller's understanding of the market value. This constitutes a failure in fair dealing and potentially misrepresentation. Proceeding with the transaction without explicitly informing both parties about the dual agency and obtaining their written consent is a fundamental violation of the Real Estate Services Act and rules. This lack of disclosure and consent negates the possibility of informed decision-making by the parties and creates an undisclosed conflict of interest, leading to a breach of fiduciary duty and professional misconduct. Professional reasoning. Professionals in British Columbia must adopt a decision-making process that prioritizes regulatory compliance and ethical conduct. When faced with a potential dual agency situation, the first step is to identify the conflict. Subsequently, the licensee must consult the Real Estate Services Act and rules to understand the specific disclosure and consent requirements. The licensee should then communicate transparently with both parties, explaining the implications of dual agency and obtaining informed written consent before proceeding. Throughout the transaction, the licensee must maintain strict impartiality and ensure all material information is disclosed to both parties, acting as a neutral facilitator rather than an advocate for one side. Question 20. During the evaluation of a property's financial performance for the month of July in British Columbia, a property manager collected $5,000 in gross rental income. The approved operating expenses for the month totaled $1,200. The property management agreement stipulates a management fee of 10% of gross rental income collected. What is the net amount to be remitted to the landlord for July? Option A, $3,800. Option B, $3,300. Option C, $3,180. Option D, $3,420. Correct answer is B, $3,300. Explanation. Scenario analysis. This scenario presents a common challenge in property management, balancing the landlord's financial interests with the tenant's right to quiet enjoyment and the property manager's fiduciary duty. The property manager must accurately calculate and communicate rental income, expenses, and net proceeds while adhering to the terms of the management agreement and the Residential Tenancy Act of British Columbia. Miscalculations or improper allocation of funds can lead to disputes with the landlord, potential legal action, and damage to the property manager's reputation and licensing. Correct approach analysis. The best approach involves a meticulous review of all income and expense records for the period, ensuring all rent payments received are accounted for, and all legitimate expenses incurred are documented and verifiable. The property manager must then apply the agreed-upon management fee percentage to the gross rental income collected. The remaining balance, after deducting all approved expenses and the management fee, represents the net proceeds to be remitted to the landlord. This method ensures transparency, accuracy, and compliance with the management agreement and standard accounting practices. Specifically, under the Real Estate Services Act of British Columbia and its associated regulations, property managers have a duty to act honestly and with reasonable care and skill, which includes accurate financial reporting and fund management. Incorrect approaches analysis. One incorrect approach is to estimate expenses or use a rounded figure for the management fee. This lacks precision and can lead to discrepancies, potentially shortchanging the landlord or misrepresenting the property's financial performance. It violates the duty of care and the requirement for accurate record-keeping mandated by the Real Estate Services Act. Another incorrect approach is to deduct the management fee from the net proceeds after all expenses have been paid. This would result in a lower remittance to the landlord than what is contractually agreed upon, as the management fee is typically calculated on gross rental income. This misinterpretation of the fee structure constitutes a breach of the management agreement and demonstrates a lack of professional competence. A further incorrect approach is to include anticipated future expenses or unconfirmed charges in the current calculation. Property management accounting should reflect actual income and expenses for the period. Including speculative costs is misleading and does not accurately represent the property's financial status, violating principles of fair dealing and accurate financial reporting. Professional reasoning. Property managers should always prioritize accuracy and transparency in financial reporting. A robust decision-making process involves 1. Thoroughly understanding the terms of the property management agreement, particularly regarding fee structures and expense approvals. 2. Maintaining detailed and organized records of all income and expenditures. 3. Performing calculations meticulously, using verifiable data. 4. Reconciling all accounts to ensure accuracy before reporting to the landlord. 5. Adhering strictly to the Real Estate Services Act and its regulations concerning trust accounts and financial management.